Daniel Vincent.
May it please the court next to prosecute that matter. Mr. Vincent is just behind me.
All right. So, Mr. Vincent, we've got 3 charges. Are you maintaining your plea of not guilty of those charges?
I still will not make a plea. I am a living being. I humbly ask for remedy, Magistrate.
All right, thank you for that. So I'm taking that as a plea of not guilty. So, estimate of a day still, Ms. Nance?
I do not consent to that, Magistrate.
Your Honour, I understand that on the last occasion, pleas of not guilty were entered on the defendant's behalf and the matter was listed for hearing. I do not believe my office was provided an estimate. I would estimate 2 hours, perhaps
2 hours.
3, noting how this morning is going. I'm in a position where I also appear in another matter of Michael Leslie Cooper listed for 4 hours today.
That's the coincidence
That is correct.
application?
Yes.
And Mr. Turner, are you in that one?
Yes, Your Honour.
All right.
I have not received a brief of evidence. I want this matter thrown out of court. I have not received a brief of evidence. I went to the police station to receive it. I've given them details of where I can be found every day at 10 a.m. and no correspondence has been reported to me. I'm asking you as the magistrate to throw this out of court, please.
All right. Well, I'm doing the call over at the moment, Mr. Vincent. So I'm going to allocate your matter and Mr. Cooper's matter to Magistrate Theakston in Court 3. So you're all free to go down there now.
Thank you. Matter of Daniel Vincent.
May I please the court next to prosecute that matter?
Okay. You ready to proceed?
Yes, Your Honour.
Okay, Mr. Vincent. Mr. Vincent.
I am Daniel Peter, a living man. Hello.
Yes, good afternoon. Are you going to come to the bar table?
I will stand here in my ground and speak to you as a living man.
Okay. Do you plan to participate in the court proceedings?
I wish to establish that I am a living being. The flesh lives and the blood flows and we are sovereign and nothing stands between myself and the divine. I will stand right here.
Okay. Well, have a seat just there. Make yourself comfortable. I'm going to proceed with the hearing. If you are to participate in the proceedings, I'd like you to come to the bar table. It's your choice. I'm happy to sit in the back of the courtroom and just observe proceedings if you wish. But you need to be aware that if you wish to participate, you need to come forward. Do you understand that?
I don't understand at all.
Okay, well, just have a seat.
I'm happy to stand right here, Mr. Theakston.
Well, it's okay. I'll let you stand there if you like. Miss Nags.
Thank you, Your Honour. Your Honour has before you a prosecutor's aid memoir. Before I open, just to address one preliminary matter, there is one police witness, Nigel Brooks, who was recently thought to be unavailable. He was on leave and not contactable via phone due to the nature of where he was on leave. He is now available via WebEx, so I seek to make an application that he appear remotely. That application is pursuant to Section 20, subsection 1 of the Evidence Miscellaneous Provisions Act.
Where is Miss Constable Brooks now?
He is in Jarvis Bay and he is able to appear via WebEx or via phone, and I have an affidavit from the informant in this matter to that effect, essentially.
Okay. Now, if the defendant was at the bar table, I'd ask him whether or not he has any issue in relation to that. Because he's not, I won't.
I'd like to ask the Magistrate, what jurisdiction is this court?
So I'm not going to answer that question. If you have an application to make, you can come to the bar table and make that application.
I ask the court again, what jurisdiction is this court? I have the right to know which jurisdiction are we in. Are we under common law, under the coat of arms of the unicorn and the lion?
Okay, I'll return to your application in a moment, Ms. Nags. Sir,
Please be noted the Magistrate will not answer my question.
I'm responding.
I will ask the Magistrate now, do you, as part of the judicial system, do you have a personal interest in this case?
So, do you wish me to answer your question or not?
Yes, I do.
Okay. You've been charged, I'll read the charge through in a tick. It's up to you to make your own inquiries. The charge makes reference to a number of acts. I'll go through this now. The first charge is 3878 of 2022. That charge reads that you and the Australian Capital Territory on the 22nd of April 2022 did resist a public official.
Isn't there a matter I've raised that still needs to be addressed? How can I under a plea or proceed until this is answered?
Okay, so if you interrupt me again, I'll ask you for you to go into custody and you can be taken downstairs and you'll be kept in custody.
I will not be threatened.
Okay, take the defendant into custody, please. He can go downstairs.
As of this point, I call section 34 of the Magistrate.
I'll clear the courtroom. I'll adjourn for a moment while that occurs.
I call on the Crimes Act 1914, section 34.
Thank you. Returning the matter of Daniel Vincent.
Yes, Your Honour, next.
Your Honour, just got a question. There's a support person. Does he know I'm here?
I have no idea. You can have a seat if you wish, or you can leave the courtroom.
Okay. As a support person, I'd sort of like to think that actually know I'm here.
Okay. Now, obviously there's been an incident. Mr. Vincent, can you hear me?
I can hear you, Glenn.
Oh, thank you for your kind words. Now, are you in a position to participate in the proceedings today, or are you just going to keep rambling on like you were before?
Are you ready to listen, Magistrate?
Okay. What do you wish to say?
I would like to know what jurisdiction I'm in.
Okay, you're now being held in custody in the Magistrates Court in the ACT. That's under 3 charges: obstructing a territory public official, assault frontline community service provider, and trespass on Commonwealth premises. Do you have any
I
other
ask the
questions?
Magistrate again, which jurisdiction am I in? What jurisdiction am I in this court?
Okay. Do you have any other questions for me?
Once again, the Magistrate won't answer a very simple
Can you
question.
get the defendant? So I've just muted you so you won't interrupt the proceedings at this point in time. Ms. Knaggs, are you in a position to proceed with the hearing today?
Yes, the witnesses are present.
Okay, so there's 5 witnesses on the witness list. Do you propose to call all of them?
Yes, Your Honour, some of the evidence will be quite brief. And again, as I mentioned, as a preliminary matter, I will seek leave that one of those 5 witnesses give evidence via WebEx.
Okay. Well, I propose to proceed now. Has the defendant picked up the brief of evidence?
I'm not aware.
Okay.
make
Can we
those
switch the defendant back on? So, Mr. Vincent, have you collected the brief of evidence?
Please wait. Here we go. Magistrate, I still don't understand. Isn't there a matter I have raised that still needs to be addressed? How can I enter a plea or proceed until this is answered? What jurisdiction am I in?
Sir, have you received a copy of the brief of evidence?
I have received no brief of evidence.
Okay. Did you attend?
But once again, the magistrate's not answering my question, so you're perverting my justice by not allowing me to know which jurisdiction I'm in.
You need to be quiet to listen. Did you attend the DPP to collect the brief of evidence? Did you attend the
Please
DPP?
wait. Please
to collect
wait.
the brief of evidence? Well, it's a simple question.
Hang on. Well, you do have me in disarray here, magistrates. Once again, magistrate, I ask you one more time.
Okay, you can mute the defendant, please. So you've just been muted, so I cannot hear you anymore.
I've asked my office to confirm whether the brief has been collected recently. There's no note of that on our system, but if that's happened today, it might not yet be on the system. So I've just asked the paralegals to physically confirm.
Now, I'd like to conduct this hearing as fair as possible for the defendant. As I understand, he can still hear me. He's refusing to engage in the proceedings other than to ask the same question again and again. It's about the jurisdiction of the court. He's not making an application contesting the jurisdiction of the court. He's simply asking me questions in relation to that. I'd like the matter to proceed as fairly as possible. Ordinarily, a brief of evidence is provided to the defendant. Ms. Knaggs, do you know if an invitation was provided to the defendant to collect the brief of evidence?
Yes, Your Honour. A letter was originally sent on the 20th of July 2022 to his PO box, inviting him to collect the brief of evidence during business hours from the DPP, as is the normal course. And another subsequent letter was sent on the 20th of July 2022 in relation to collection of the brief of that evidence and a late provided police statement in addition to the original brief. So
Okay.
2 letters in total inviting the collection.
On the same day?
No, 21 June and 20 July.
I see.
Excuse
Okay.
me, Magistrate, I
No.
may be able to help if you want.
No, I'm not interested in hearing from you.
That's fine, I'm just offering.
I'll hear from the defendant in due course. Look, Mr. Vincent, I'm going to describe the process for you so you know what to expect. You can choose to listen, you can choose to talk if you wish, but this is your opportunity to understand the process. What I propose to do is conduct a hearing at some point, and that may be today, maybe some other day. At the hearing, the prosecution will open by describing what they say occurred. They will describe the offence and perhaps the elements of the offence. I'll then give you the opportunity to be heard in response to that opening. That involves you identifying what facts you agree with, what facts you disagree with. It's a voluntary statement. You do not need to respond to the prosecution opening. At that point in time, I'll then invite the prosecution to commence their case. They can call their witnesses. You'll be entitled to cross-examine their witnesses should you wish to do so. There are rules in relation to that. I won't give you legal advice about those rules, but you will have that right should you wish to ask questions of the prosecution witnesses. After that cross-examination, the prosecution will then or may have further questions of those witnesses in a limited fashion, and then they'll then move on to the next witness. Once the prosecution case is completed, I'll then turn to you and invite you, should you wish to do so, to give evidence and to call any evidence you wish to call. If you wish to give evidence, you should do so first before you call a witness. You do not have to give evidence. You do not have to call a witness. You have the right to remain silent. You do not need to participate in the proceedings in an active way, but you should not disrupt the proceedings either. Now, once that's done, we then turn to closing addresses. The prosecutor will address me and explain to me why she thinks you should be found guilty of the offences charged. And I'll invite you to address me as well. Again, you don't have to. And ordinarily a defendant will try and persuade me why they should not be convicted or found guilty of the offences charged. Now, I'll ask for your mic to be switched back on. Do you have any questions about that process?
Magistrate, I wish to establish that I am a living being, the flesh lives and the blood flows. We are sovereign and nothing stands between myself and the divine. This is the third time I've said this, and I am still have no idea which jurisdiction I am in, and I want to ask why I have no judge and jury of my peers as is my inalienable rights by common law.
Now, sir, I'm minded to proceed.
Last chance, Magistrate.
I'm minded to proceed to the hearing today unless you wish to be heard otherwise. Do you wish to be heard otherwise? Do you, for example, do you seek an adjournment of the hearing today?
Magistrate, if you will not listen to me, I can sue you under common law for violating my rights under the Uniform Commercial Code. I have remedy under the UCC to reserve my rights under the common law. I have exercised the remedy, and now you must construe this statute in harmony with the common law.
To be microphone off again. Thank you. Sir, you are now muted. I cannot hear you. Yes, Mr. Nags, we'll commence the hearing today. So please commence with your opening. Sorry, in relation to your application for...
It is an application that Constable Nigel Brooks be permitted to give evidence remotely via phone or WebEx, whichever is most suitable to the court.
Okay.
I make an oral application and rely on the affidavit.
And he's in the Jervis Bay Territory, is that right?
That's correct.
And is there any reason why he couldn't be here today?
As outlined in the affidavit, I understand essentially, and I found this out on Friday afternoon, that there was some sort of police scheduling oversight and he was not scheduled to attend this hearing. I then confirmed yesterday that he would be able to give evidence via phone, and then this morning I was informed by police that he would be available to appear via WebEx. He is one of, as you said, 5 police witnesses, and he captured body-worn camera footage of the incident that I also seek to learn.
And which rule or which section?
Regulation 6800 of the Court Procedure Rules and Section 20, subsection 1 of the Evidence Miscellaneous Provisions Act.
Section 20, subsection 1?
Yes.
Okay, I'm going to ask you a question, sir, and then once I've finished asking the question, I'll turn your microphone back on. There is an application by the prosecution for Constable Nigel Brooks to give his evidence remotely by audio-visual link from the Jervis Bay Territory. I'm minded to grant that application because in my experience the connection can be quite reliable and quite clear. and it certainly is the quickest way for him to give his evidence in the circumstances. But there may be a reason why you think it's inappropriate, so I'll be asking you whether or not you wish to be heard against me making that order. So I'll ask for the microphone to be turned on. So, sir, having heard that, do you wish to be heard in relation to me making that order?
Not allowing judge or jury as my lawful right, I now state Crimes Act 1914, section 34, subparagraph 4. I want you placed under arrest as a person commits offence if the person is a magistrate or...
The defendant's microphone. Thank you, sir. I've just muted your microphone. So I'll make an order. That is that Constable Nigel Brooks can give his evidence remotely from the Jarvis Bay Territory via audio-visual link. Okay, so let's start with your opening, Ms. Nags.
Thank you, Your Honour. On Friday the 22nd of April 2022, protesters gathered at the front of Government House at Dunrussell Place in Yarralumla on Commonwealth land managed by the National Capital Authority. A direction was given by the NCA that the protesters not camp on the land. Police that day were informed that the protesters intended to camp on the land. At 6:20 p.m. that day, Detective Inspector Craft of the AFP issued a direction to protesters to move on by 9:30 p.m. At 9 p.m, Detective Inspector Craft reminded the members of the group to move on, and he was informed that the group did not intend to move on. At 9:30 p.m, protesters were directed to leave the area again. At 10:20 p.m, Detective Inspector Craft used a police loudhailer to again provide the move on direction to the group. It is alleged that at 10:25 p.m. that day, the defendant had not moved on. Police approached the defendant and said, "You've been provided a direction to move on from the area. Do you intend to leave?" And the defendant replied that he did not. Prosecution alleges that as police then took hold of the defendant's arm to place him under arrest, the defendant resisted police arrest by dropping to the ground and pulling police to the ground and continuing to struggle, thereby resisting and hindering police in their duties. It is further alleged that during the time that the police were performing their functions, the defendant kicked out his foot, which struck Detective Inspector Craft in the groin area, causing him pain. Much of the incident was captured on body-worn camera, and the defendant subsequently also participated in a recorded interview when he made various admissions and denials about the allegations. The first witness the prosecution intends to call is Detective Inspector Craft.
Okay. Sorry, just one moment. So that's the prosecution opening. So, Mr. Vincent, I'm going to, as far as I possibly can, allow you to decide to participate in these proceedings at any step. In a moment, I'll ask for your microphone to be switched back on. The purpose of this response is for you to indicate if you agree with anything that's been said by the prosecutor. You don't have to make a response to our opening. Do you wish to make a response? And ask for the microphone to be turned back on.
No, sir. Magistrate, as you're not listening to me, and as I saw you abandon ship by leaving before after 3 times declaring I'm a living man, and because I do not have the brief of evidence as I was supposed to be supplied, I am now calling you for dismiss the case or at the very least adjourn it.
Okay. Sorry, Detective Inspector, I'll just ask you to wait outside just for a few moments. Okay, I'm listening. Why should I adjourn the hearing?
Because I do not have the brief of evidence which was supposed to be supplied to me at least 72 hours before. I have not received it. They have no evidence I've received it, and I've made myself very willing to. I've been to the police station to receive it. I'm available 10 a.m. every day as notified to them for them to bring it to me like they have others. So now, yeah, there is no brief of evidence. We cannot continue. I demand you dismiss the case.
Okay.
Preferably, at the very least, you should adjourn it.
Why do you say?
Because this definitely isn't going and you're not listening to me.
Do you say there's a requirement to serve it 72 hours before? Where does that come from?
They're your rules, but yeah, I deserve legal representation. I deserve to be able to prepare my case in this court.
I agree. You have that right, and that should be provided to you. Ms. Nags, what do you say to the application for the adjournment?
Your Honour earlier inquired whether it had been collected. I can confirm it was not collected, the brief.
Yes.
I don't wish to be heard noting what the defendant said about legal representation and the brief of evidence, and also noting that the hearing was listed on the last occasion in absence of a plea. I'm able to have the brief brought over to court within the next 10 minutes if that assists. Otherwise, the ordinary court is to collect.
Okay. So, Mr. Vincent, I'm minded to grant the adjournment. How much time do you think you need to consider the brief before we can continue with the hearing?
Well, I need to get things ready, let's say at least a month. Because you're not listening to me, Magistrate, and what I'm citing are law, and you're blatantly not listening to me. I've called for your arrest. You've broken the law as per section 34 of the Crimes Act 1914, subparagraph 4. Person commits offence if they're a magistrate or judge, and the judge or magistrate perversely exercises jurisdiction in the matter. I've asked 3 times, I've been to 3 courts, 4 courts, saying that I'm a living man and demand my judge and jury by trial. You have denied me this, and you're not even listening. So this is unfair. There is no justice here. I'm not playing your games. I'm standing my right in Jesus' name.
Is that the full meeting? Okay.
The sheriff should be in there arresting you, Glenn Theakson.
Ms. Snaggs, would your witnesses be available on the 14th of December?
I may briefly have a moment.
Yes.
And at the same time, I asked the magistrate to assure there are no bail whatsoever, as per my right 83.4 to peacefully protest, which is why I shouldn't even be here.
Was it the 14th of December, sorry, Your Honour?
Yes, 14 December.
Yes, that appears to be suitable. Constable Brooks, who has been largely unreachable, I haven't been able to confirm his availability, but noting the order already made.
Okay. So the 14th of December, is that suitable to you?
It will have to do.
Okay.
But I'm calling for your arrest, mate. The sheriff should be there arresting you, Glenn Theakson.
I've heard you say
You
that
are the magistrate perversely conducting justice here.
Ms. Snaggs, how long can the brief be provided to the defendant before he's released?
Yes, I've asked.
Please let it be known the clerk of court now is unlawful. They should be calling the sheriffs for your arrest.
The defendant's been muted again. Sorry, what was that?
I've asked the paralegals, they're on their way with the brief of evidence to the court.
Now, I'm minded to grant the adjournment to the 14th of December. What do you say in relation to the question of bail?
I have not turned my mind to it. Perhaps...
Now, I directed the defendant be placed in custody because of the way he's behaving in the courtroom. I left the courtroom. Now, there was a struggle of sorts. I'm not quite clear what happened. I don't know if that involved only the defendant or if it involved the defendant at all. Do you need to take some instructions in relation to the question of bail?
Yes, that could possibly be done quite quickly, noting that the relevant officers are present at court.
Okay.
If I could have 5 minutes just to turn my mind to appropriate conditions.
Yes, okay. I'll adjourn the matter for 5 or 10 minutes. Thank you. Yes, thank you. Return the matter of Daniel Vincent.
Thank you, Your Honour. For the record, next to prosecute. Thank you
Yes.
for that time. There's no application by the prosecution to revoke or to continue the revocation of bail, but the prosecution would propose perhaps some conditions, namely that the defendant not assault, threaten or harass any witnesses in the matter, and a condition that perhaps he not be within the court precinct or within 50 metres of the court precinct unless named in or with a legitimate purpose to attend court proceedings.
Okay. And the witnesses are those on the witness list, is that right?
Yes.
Okay. And has the brief been provided to the defendant yet?
I have the brief here. It's
I'll ask
just
that to be sent down straight away, so he's served essentially in court.
the sheriff will take that brief
Okay,
to the
thank
remote
you.
witness room where the defendant will collect.
Okay. So what order do you seek or condition do you seek in relation to the court?
Noting the incidents that occurred within the court, I understand there's also a significant presence at the front of court, perhaps a condition that the defendant not enter the court premises or be within 20, whatever Your Honour sees fit, of the court premises, 20 metres, except when named in a court proceeding or for a legitimate purpose, for example, being subpoenaed as a witness in a court proceeding. I'm in Your Honour's hands. There's certainly no application to revoke bail.
Okay, I'll ask for the defendant's microphone to be switched back on. So having heard that, do you wish to be heard against those additional conditions?
I have heard, And preliminary, I don't agree, but I would like the advice of my offsider there who's sitting there, Phil, if he can give me his advice on the matter. But at the moment, I don't agree to any bail conditions. I've never been a danger to the witnesses, and I've never been a danger to this court. And as it is at the moment, you abandoned ship, and I'm the most senior person in this courtroom, and I dismiss these charges.
Thank you. You've been placed on mute. Just bear with me one moment.
The existing bail conditions are to reside as directed by ACT Corrective Services, not to be within 200 metres of Government House, not to be in the suburb of Yarralum or Parks ACT, and to comply with all reasonable directions and to report to ACT Corrective Services Court intake the next day. Bail was granted on those conditions, and I understand continued on the next occasion. It certainly doesn't appear to be an issue with the defendant attending court, but noting the original conditions in relation to Government House and noting the incident that was observed in part in the courtroom today, I would submit that it would be appropriate to include some conditions.
So keep in mind, I didn't see what happened. So,
yes.
So from the bar table, what do you say happened?
I also stepped quite quickly out of the way. I understand that the defendant essentially resisted going into custody, and that a melee or a scuffle broke out in the attempts to put him into custody, but I certainly didn't see anything in much detail.
Look, what I might do is ask the Sheriff to come forward just to give some evidence as to what happened in court in my absence. Sorry, were you both there?
I solemnly and sincerely declare and affirm the evidence I give with the truth, the whole truth, and nothing but the truth.
Okay, thank you. Yes, Ms. Nags, if you don't mind leading the evidence.
Thank you, Sheriff. Could you please state your occupation at the court precinct?
Yeah, I'm Deputy Sheriff of the ACT Law Courts.
And what were your duties today?
My duties were Deputy Sheriff duties.
Thank you. Did you have cause to attend?
And sorry, and your full name?
Peter James Robertson.
Thank you. Did you have cause to attend this courtroom being courtroom 3 earlier today?
I did.
And what, if anything, did you observe taking place in courtroom 3?
The first thing I observed with Mr. Vincent, who was to appear in court, was directed to be remanded in custody. He refused to go with the corrections services, and they requested him. They were then required to use force to remove him from the court premises. Soon after this, another gentleman forced their way into the courtroom, which was a breach of the current Section 50 order, that only the accused and the support person were admitted into the courtroom.
How long would you estimate it took corrections and security staff to apprehend the defendant and take him into custody?
Estimation would have been 30 seconds.
And did you observe any, for want of a better term, physical violence on behalf of the defendant?
Not violence, it was resisting their attempts to remove him from the courtroom. He was directed multiple times, refused, and then force was used to remove him.
In your capacity as Sheriff's Officer, did you hold any concerns for the safety of people within the court precinct?
I did, and you always do when force is needed to be used.
No further questions.
Okay. Now, Mr. Vincent, I'm going to give you the opportunity to ask the Sheriff any questions. I'll turn your microphone back on. Do you have any questions for this witness?
I'd like to ask the Sheriff why he's not arresting you, Magistrate Theakson, for basically for what
microphone. Okay, thank you. Ms. Nags, I'm not minded unless there's a good reason to list the witnesses on the bail conditions. Can you describe a good reason for that?
No, Your Honour, I don't press that.
Okay. And in relation to excluding this person, this defendant from the court precincts, is there a reason besides that he might create a problem in the future, which could not be managed by a Section 50 order?
Certainly the basis of that submission is simply what transpired today in terms of a risk to other court users and the requirement of a use of force. I don't... it's my submission that condition would go to an extent to ameliorating risk to the public, noting that the original offences charged were ones of resisting arrest and assault. It would be my submission that today's incident may, in a way, mirror that same sort of offending that poses a risk to the community. However, I'm certainly in Your Honour's hands.
Okay. Now, Mr. Vincent, I'm going to turn your microphone back on. Do you wish to say anything further in relation to submissions as to what I should do with the bail conditions?
Yes, there should be no bail conditions. I prove no risk to you, the court or the witnesses never have and never will. I want to hear my matter in court with justice, not games, Magistrate.
Okay. Now, is it the case the defendant has received the brief evidence? Is that right?
If I could just step away from that.
Yes. Have you seen it?
Yes, I understand it's gone down and was handed by the officer to the defendant.
Okay, thank you. I'm going to continue bail as it is. To my mind, the need to manage the safety of the court precinct can be managed using the Section 50 powers, if necessary. And that includes the power directed towards this defendant should that turn out to be necessary. So, defendant, so you're remanded to appear on the 14th of December 2022 at 10 a.m. That's part of it before myself for hearing. The matter's listed for 1 day and bail is to continue. And I note, I'll mark at the bench sheet as well, that you received a copy of the brief of evidence while in custody. Okay, anything further?
I receive no justice here and you're a criminal, Glenn Theakston.
Okay. Yes.
And you should be arrested.
Apology.
May I please go?
Please stand.